The continuation of the impeachment trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order. We shall be led in prayer by Senator P.S. Cayetano.
Let us put ourselves in the presence of the Lord. We offer up this prayer through a poem which is entitled True Justice. Enthroned upon the mighty truth within the confines of the laws, true justice sees not the man, but only hears his cause. Unconscious of his creed or race, she cannot see, but only weighs. For justice with unbandaged eyes would be oppression in disguise. This is a poem by Paul Lawrence Dunbar. Our God and Father in heaven, as we go through the difficult and sometimes painful process of finding out the truth in relation to the issues at hand, we humbly ask for the gift of extraordinary wisdom to enable us to distinguish between conflicting issues and claims, to do what is right by your standard and by the standards of our laws, always remaining faithful to the oath we took as senator judges. We would also like to say a special prayer for the bar examinees. May those who successfully pass the bar exam be true vanguards of the law. In this we pray, in Jesus' name, amen.
Amen. The Secretary will now call the roll of senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Panglinan, Pimentel, Rector, Villas, Soto, Trillanes, Villar, the Senate President.
With 20 senator judges present, the presiding officer declares the presence of a quorum. The Sergeant at Arms is directed to make a statement, the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 28, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Any objection? There being none, the February 28, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Please call the case, Madam Clerk of Court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances. Majority Floor Leader.
For the prosecution, Mr. President.
Good afternoon, Your Honors. For the prosecution panel of the House of Representatives, same appearance, and we are ready, Your Honors.
For the defense.
Noted. Defense.
For the defense, Your Honor, the same appearance. We are ready also.
Noted.
Mr. President.
Majority Floor Leader.
Yes, Mr. President, thank you. Before the business of the day, yesterday, the Minority Leader was asking for the floor. So may we recognize the Minority Leader, Senator Alan Cayetano, Mr. President.
The gentleman from Taguig.
Magandang hapon, Mr. President.
The Minority Floor Leader.
Mr. President, yesterday when Congressman Nery Colmenares brought up certain topics, I asked to be recognized today because I did some research dwelling on the immunities of Supreme Court justices because of this INRE Raul Gonzalez, which practically states that a member of the Philippine Bar, that it is a qualification to become a justice, that you have to be a member of the Philippine Bar. And you cannot file a disbarment case during the incumbency of a justice, nor can you file a criminal case before the Sandigan Bayan of any offense which carries with it the removal from office, meaning the only way to address issues of transparency and accountability to justices is through an impeachment court. The President only has a immunity from suit for his term of 6 years, but since the justices retire at the age of 70 years old, they basically have a much longer time of immunity in effect, no? because of what some people term procedural immunity. And I see the point of this. You cannot see a situation wherein a Supreme Court justice is being tried before the Sandigan Bayan, and then the appeal will be before the Supreme Court. And at the same time, they passed a resolution, and to be fair to this Supreme Court, it was the previous members that basically made it very difficult, if not almost impossible, for anyone to get a copy of the SAL-N. No? And so, basically, Mr. President, ang sinasabi ko po, with all of these immunities, ang takbuhan lang ng tao po yung impeachment court. Pero kung ang magiging desisyon po ng Supreme Court is that every step of the way, whether pagsusupina ng kanilang records, ng mga tao, etc., ay hindi pwedeng kunin, lalong nasa-strengthen yung kanilang so-called immunity. So, saan katatakbo? Parang may problema tayo, which came first, the chicken or the egg, no? Kukunin mo ba yung ebidensya at kakasuhan mo ba muna siya bago ka dumating ng impeachment? Or pag nasa impeachment na, sasabihin na saan ang ebidensya, magiging technical tayo, and hindi mo naman pwede silang kunin ng witness, hindi mo pwedeng kunin yung records. Samantalang malinaw naman sa lahat ng court rulings abroad na ang judicial misconduct is one of the exceptions to opening up their records, no? Regardless if the case is pending before them or not. The Neri case, which dealt with executive privilege, very, very clear yung umpisa niyang statement. Executive privilege cannot be used to excuse a crime. So I wanted to go into a discussion, Mr. President, an academic discussion rather than a ruling on the points that we have already ruled upon, because of my concern that whatever we do here will set a precedent. No, magiging basihan to ng future impeachments. I hope we will never have to go through this again with any of the other justices. I do know that tama po si Senator Miriam, let's talk about the country, let's talk about the future. Napakahalaga na yung integrity ng Supreme Court intact. Pero Mr. President, yun din po ang sinabi kasi natin sa militar nung sinabi natin wag imbestigahan, sinasabi lang wag imbestigahan si General Garcia, wag pag-usapan ang pabaon, wag pag-usapan ang mga nangyayari. But this actually strengthened the military, and the reforms that came afterwards actually strengthened the military. So I think there are good intentions in asking the Supreme Court to release some of their records or to make themselves subject to this impeachment court. Let me just put on the record, Mr. President, that some of the confusion is because of the name. Ang tawag po kasi natin ay Supreme Court. If we put the name Supreme Impeachment Court, magkakaroon ng context ng konti. Kasi lahat po ng justices, whether collectively or individually, is subject to the impeachment court because they are impeachable officers. Hindi natin pwedeng sabihin na pantay natin sila sapagkat lahat ng dapat magsasubmit sa jurisdiction ng court ay mas mababa sa korte. But, Mr. President, this will go into a discussion of the difference between dealing with the Supreme Court itself and members of the Supreme Court. So be that as it may, Mr. President, I was overtaken by some events, and I think we agreed to talk about this in caucus instead. I know it is a very sensitive issue, but let me just reserve some time after our caucus or at the appropriate time, Mr. President, to talk about how the impeachment court can balance these two very important interests. One, which is the respect of a co-equal branch of the Senate, which is the judiciary, not a co-equal branch of the impeachment court. Number two, Mr. President, is the integrity of the adjudicatory process of the Supreme Court, its record, its people, how to ensure that ang justices natin ay protektado at hindi sila yung yunuyugyog o sila ang kinakasuhan or yung independence ng judiciary. Napaka-importante yon. But at the same time, we know that absolute power corrupts absolutely. And alam po natin that there can be no person or no branch of government that can have absolute immunity. So, Mr. President, I just wanted to put this on record, and I prepared a legal study and some cases that we researched. But let me stop here, Mr. President, and discuss it in the caucus, and then maybe at the appropriate time we can have a discussion just for the records, as I said, because this will be a precedent, and it will be very, very difficult to impeach a erring Supreme Court justice if these issues aren't resolved. Thank you very much for this time, Mr. President.
Thank you.
Mr. President, Senator Pia Cayetano is seeking to be recognized, and while she is preparing for that, may I just call the attention of the Clerk of Court to page 54 of the journal, wherein the last line is acknowledged to the Senate President or the presiding officer, but this is Senator Drilon, just to make the proper correction. Typographical error, most probably. Anyway, for the record. So, Senator Pia Cayetano, Mr. President.
Thank you,
The
Mr.
gentle lady from Taguig.
Thank you, Mr. President. Mr. President, on Monday, February 27, the prosecution offered as evidence the testimony of one of their witnesses, Edmond Yasala. And in the journal of said date, it states, among many others, the purpose of why his testimony was offered. I will quote, "To prove that Respondent Corona, using his administrative powers as the Supreme Court Chief Justice, extended office hours so that the TRO condition can be fulfilled by GMA, and thus allowed GMA and then First Gentleman to leave." I was very interested in this allegation and was looking forward to the presentation of evidence on this matter, Mr. President. But let me move forward. Yesterday, Senator Lawrence stood up and she asked for clarification because she did not recall that there was any testimony given by any witness as to prove that, in fact, the office hours were extended. So I was intently listening to the query and to the response given to Senator Legarda. I refer to page 37 of our journal, wherein the statement, or should I say, the testimony of the prosecution, I refer to Attorney Pareño, refers to certain times. There was 1:30, 3 o'clock, and 4:30. Mr. President, I would like to put on record that the statements of counsel on the time that certain activities were taken, certain activities took place, have absolutely no bearing on this impeachment court. It will be recalled that it was counsel who testified on those times, and I would like to know if counsel has now offered himself as the witness. Has counsel taken an oath, perhaps, when I stood out for a few minutes? I just don't want people, whether non-lawyers or the millions of Filipinos who are watching, to be confused because there was no evidence that I can see in the record and that I have witnessed with my own eyes on the witness stand. Having said that, Mr. President, I refer back to the query of Senator Lauren Legarda, and in fact, section 37, page 37 of the journal will bear out her concern that the only reference to time provided by counsel, not by the witness, if I may emphasize again, was 1:30, 2:30, 3 o'clock, and 4:30 p.m. Mr. President, I mention this because I belabor this point because they used our time. We spent so many minutes trying not to fall asleep watching that video. So if there is no testimony that will accompany that video, can we please be more conscious of this? Or if the one who will testify on the video will be the lawyer, then please take the witness stand, so that we do not waste the time of counsel, our researchers, our people, in trying to understand what is evidence that we must use in deciding this case. This becomes even more relevant because the prosecution has rested. So I leave this point, Mr. President. I don't require a response, but if the prosecution cares to respond, I am more than happy. Thank you.
The chair would like to state for the record that these statements, personal statements of the lawyers representing either side of the adversarial proceeding are not evidence. They are just a plain statement, manifestation, and they will not be taken into account as proof of anything except that they said it. Anybody who wants to respond to the lady senator from Taguig? From the prosecution side.
Your Honor, the statement of the senator is well taken. Actually, the intention of the video is part of the building block of the presentation of the prosecution. However, in light of yesterday's development, Your Honor, that we can no longer present the other witnesses like the process server, which we would have wanted to prove the extension of office hours, we cannot go further on that, Your Honor. But thank you for that clarification. I think the Senator didn't want us to respond, doesn't need a response. But yes, we clarified that it's part of the building block, Your Honor.
Only statements given under oath by somebody sitting on the witness stand is evidence.
Mr. President.
So,
Mr. President. Yes,
Leader.
may we now proceed with the business for the day, and this is
Proceed.
the continuation of the cross-examination of witness Mr. Danny Piedad of ABS-CBN by the defense. So may we call on the witness, Mr. President.
You may call now the witness who is going to be subjected to cross-examination under the same oath.
Your
Let
Honor,
him take this stand.
Your Honor, Attorney Al Pareño, Your Honor, for the prosecution.
Yes. What's the
Good afternoon,
pleasure of Attorney Alvarin?
Your Honor, I'm just going to be for the presentation for the cross-examination, Your Honor. I will be for the prosecution, Your Honor, for the cross-examination of the defense. I'm really here, Your Honor, to
It's, to me, as a presiding officer, I'm confused about these things. Why do you have to designate somebody to stand up to attend to your the witness? In a cross-examination, any one of you can stand up
Yes,
to
Your Honor.
object.
It's just that he was the one who conducted the direct, Your Honor. So
All right.
may we call the witness, then look at that.
And before we proceed, now, may I suggest, gentlemen, on both sides, you're putting this court in a very serious predicament because you already make pronouncement about the weight and the quantum of the evidence that you have presented for your side. No one can be sure of the outcome of this case, even if you have presented your evidence. We'll wait for the completion of the entire trial until a judgment can be pronounced. Now, those who practice law extensively are not sure of their case until the entire case is over. So please do not make sweeping statements outside that may befuddle or confuse the people or convince them na panalo na kayo. Wala pang panalo dito. Huwag kayong maniniguro. Baka pagkatapos sasabihin ninyo, natalo kami dahil yung mga senador na suhulan. Dahil malakas yung aming kaso. Hindi ganun eh. Ang paglilitis. So, I hope you will take this advice because we have to be truthful to our people. Okay? So, proceed.
With the kind permission of the Honorable Court, Your Honor.
Proceed.
Anong pangalan? Good afternoon, Mr. Piedad. Magandang
Good afternoon
hapon po
po.
sa inyo.
Good afternoon po.
Nung binabasa ko yung transcript ng inyong testimony, napagalaman ko na kayo ay taga ABS-CBN.
Tama po.
At naroon kayo bilang photographer for almost 11 years. Tama ho ba?
Opo, tama po.
Nagsimula po kayo ng magkano ang inyong sweldo?
Objection, Your Honor. Your Honor, that specific question is not material to the direct examination.
He's under cross. He's not under direct. The cross-examiner is testing this witness. Proceed. May answer.
Nung nag-start ako noong 2001 na cameraman, per hour po kami noon eh. So, mapatak lang po ng 54 per hour. 54 pesos po per hour.
Magkano po yun isang buwan ang inyong sweldo nung panahon na yon?
Depende po sa sa dami ng oras na ipinasok namin.
Yeah, but more or less, magkano po ang sinasahod ninyo?
Sa isang buwan po, pwede pong pumalo ng mga 18,000.
Isang buwan.
Opo.
At yan nadagdagan. Samantalang kayo tumatagal sa inyong serbisyo.
Opo, tama po.
Nang kayo tumistigo rito noong nakaraang araw, magkano na po ang sweldo ninyo bilang photographer?
Your Honor, may I just make a quick objection on the question, Your Honor? Because it might affect certain confidential matters regarding the circumstances of the witness when he is asked on questions regarding
What
salary.
confidential matter?
He's asked about what his salary is, Your Honor. It might affect the...
What is the confidentiality of a salary of a witness?
Only if the witness is willing to answer, Your Honor, but if he's not, I would like to presume that he doesn't want to divulge his salary, Your Honor.
Is that incriminating? May we be allowed to know, Your Honor?
The witness may answer.
35,000 din.
A month. At kasama po ninyo dyan sa pagiging photographer ng ABS-CBN, si kagalang-galang na photographer Leo Salia.
Opo.
Yung tumistigo dito kamakailan sa panig ng prosecution. Tama ho ba yun?
Opo, tama po.
Magkasama kayo sa isang division o sa isang larangan na saklaw ng ABS-CBN.
Opo, tama po.
Natatandaan ko po, alinsunod sa inyong deklarasyon na noong Nobyembre 15, 2011, assigned kayo sa isang mission para saksihan o kunan ng video ang magaganap doon sa isang department ng gobyerno, yung department MNDA, tama ho ba po?
Opo.
And that was mga anong oras po noon?
Nung morning po ng November 15, ang assignment namin sa about the cancellation ng mga bus franchise. So ang regional assignment namin that morning is to cover the DOTC and MMDA in the afternoon.
Ang tanong ko po sa inyo, yung mga anong oras noon?
Morning po kami nagpunta ng DOTC and then afternoon na po sa MMDA.
So,
mga 2 o'clock po.
2 o'clock, opo. Sino po ang nag-assign sa inyo? Yun ho ba'y voluntaryong ginawa ninyo o merong assignment kayo buhat na nakatataas sa inyo?
Ang usual routine po na
Yung araw lang na yun ang tanong sa inyo.
Opo, nautusan po yung reporter ko na mag-cover ng storya na yun sa bus franchise.
Sino po yung reporter ninyo na yun?
Si Miss Sen Hernandez po.
At inutusan naman kayo nitong Mr. Hernandez na maging isang photographer doon sa mangyayari sa MMDA nung araw na yun.
Opo.
Tama ho bang sabihin ko na yun ay mga alas 11 hanggang alas 2 ng hapon?
Pwede po.
Pwede. Kasama ninyo doon si Mr. Leo Salia po. Hindi po. Hiwalay kayo?
Hiwalay po kami na assignment.
Hindi kayo nakita nung araw na yun?
Hindi po.
Alright. Now, meron kayong binanggit sa inyong deklarasyon, direct examination, na nasa airport naman kayo nung bandang hapon nung araw na yun, Nobyembre 15, 2011. Tama ho ba yun?
Opo, opo.
Alright. At nandoon kayo sa inyong sariling kagustuhan o assignment o dahil sa assignment ninyo?
Nasabi ko po doon sa unang statement ko, napunta po kami doon dahil nakipag-appointment po kami kay Chairman Tolentino ng MMDA na doon na kami mag-ambush interview dahil aalis siya ng bansa. So kaya po kami napunta.
Hindi po ninyo sinasagot ang tanong ko sa inyo. Kayo ba'y nandoon sa airport? Doon sa
Opo.
mga oras na binanggit ninyo, sapagkat voluntaryo kayo nagpunta roon o sumusunod kayo sa utos ng isang nakatataas sa inyo?
Sumusunod lang po sa utos ng reporter.
Ano po ang utos sa inyo ng reporter? Pwede ho bang malaman ang kagalang-galang na hukumang ito?
Ang pagkakasabi niya sa akin, si Chairman Tolentino po ay pupunta ng airport. So doon na po namin siya i-interviewin.
So,
Kaya po kami nandun.
sumagatid po, ang inyong mission ay para interviewin si kagalang-galang na Chairman Tolentino.
Opo, tama po.
Wala pong kinalaman nyo sa pag-alis ng kagalang-galang na GMA.
Opo, tama.
Meron kayong in-identify ditong video tungkol doon sa pag-alis ng kagalang-galang na GMA. Tama ho ba yun?
Opo.
Paano po nangyari ng inyong assignment para makuna ng video yung pag-alis ni Chairman Tolentino at napasama si kagalang-galang na GMA sa inyong video?
After po namin mag-interview sa airport kay Chairman Tolentino, nag-stay po kami doon sa airport dahil meron na hong ENG van na naka-standby doon. Ito po yung nagtatransmit ng mga materials namin. Since yung oras po wala na. Kumbaga, kakapusin na po kami ng oras para mag-back to base para sa materials na unang istorya namin. Ay nag-feed na po kami ng materials. Habang naghihintay po kami ng feeding ng materials, suddenly yung reporter ko na sinabihan ako, baka mag-stay tayo dito.
Ano po ang kinalaman ng pag-alis ng kagalang-galang na GMA doon sa inyong takdang pakikipagtakpo kay Chairman Tolentino?
Wala
May kinalaman ho ba?
Wala po, Your Honor.
So hindi ninyo alam kung aalis nga o hindi ang kagalang-galang na GMA?
Wala po kami hindi.
Alright. Yung anong oras po yun na sabihin ninyong aalis?
Natatandaan ko po mga around 4 to 4:30 po. Sinabi ng reporter ko sa akin na
Yun ang
may
oras
info daw po na aalis
Sa mga
si GMA.
Kung walang sinabi sa inyo yung reporter ninyo, wala kayong maipahahayag sa kagalang-galang na hukumang ito tungkol sa pag-alis di umano ng kagalang-galang na GMA.
Opo, Your Honor.
Tama po yun?
Tama po.
Alright. Kilala ba niyo si kagalang-galang na GMA? O sa pangalan lang?
Sa pangalan po at sa mukha po. Siya.
Hindi ninyo siya nakausap kahit kailan?
Hindi po kahit kailan.
Nung araw na kinunan ninyo ng video, tama ho ba ang aking palagay na hindi ninyo nakadaupang palad o nakausap man lang kahit saglit ang kagalang-galang?
Hindi po, Your Honor.
Alright. Alam ba ninyo kung saan siya pupunta noon?
Wala po ako alam.
Ayan. Hindi rin ninyo alam kung bakit siya nasa airport nung oras na yon?
Wala rin po kaming idea.
Ang nalalaman lamang ninyo na pinagtapat ninyo sa kagalang-galang na hukuman ay yung di umano merong aalis ang kagalang-galang na GMA. Tama ho ba yun?
Opo, tama po.
Alright. Ano po ang kinalaman ng pag-alis ni GMA sa inyong pagiging assigned doon sa airport?
Since
Wala.
wala po kami idea na...
Aksidente lang ang pagkakaroon ninyo.
Sabi kasi ng reporter ko na...
Hindi kayo, hindi ko. Sige po, I'm sorry.
Sabi kasi ng reporter ko, mag-standby lang kami doon.
Yun lang
po.
Yun lang ang dahilan. Kaya nagkaroon kayo ng pagkakataon na makuna ng video ang alleged na pag-alis ni kagalang-galang na GMA.
Opo, Your Honor.
Alright. Alinsunod po sa inyong deklarasyon na aking natunghayan dito sa record, mga alas 9 na ng gabi noon, tama ho ba?
Hindi pa no, mga 8:30 po to 9 ganun po.
Kaya nga, alas 8:30 hanggang alas 9 ng gabi.
Opo.
Hindi ninyo alam kung bakit siya aalis.
Wala po akong idea.
Hindi ninyo alam kung anong dahilan ng kanyang pag-alis.
Hindi rin po.
That will be, maraming salamat po. That's all with the witness, Your Honor.
Any cross, any redirect?
No redirect, Your Honor.
All right.
Thank you.
The witness is discharged.
Thank you, Your Honor.
Majority Floor Leader.
Mr. President, as manifested during yesterday's trial, the prosecution will no longer present evidence with respect to Articles 1, 8, 4, 5, and 6 of the verified complaint for impeachment, but reserves its right to present evidence on the dollar accounts of Chief Justice Corona.
Only on Article 2.
Yes, may we now call on the prosecution? May we know the pleasure, Mr. President? Oh, yeah, before we do that, I'm sorry. I withdraw that request, Mr. President, and ask that Senator Miriam Defensor Santiago be recognized.
The gentle lady from Iloilo.
Mr. President, yesterday you were struck by a thunderbolt. All of a sudden, the prosecution stood up and said, we have 8 articles of impeachment, but we are no longer presenting or withdrawing at least 5 of those articles, leaving us with only 3 articles of impeachment. In my entire career as an RTC judge of Quezon City, I have never seen a lawyer in a civil case, which is in this instance parallel to an impeachment trial, withdraw any cause of action that he told the court he would present evidence on. That has never been done. An impeachment trial is like a civil trial and like a criminal trial. An RTC judge's jurisdiction over all kinds of trials, civil, criminal, and special proceedings. I have never heard, apart from my own individual experience, I've never heard of a civil case where there are several causes of action, where the lawyer suddenly says to the judge, I'm sorry, Your Honor, made a mistake. I now want to withdraw or drop more than half of my causes of action. This is unprecedented. That is why I feel obliged as Senator Judge to enter into the record my very serious concern about this development. Number one, counsel, you please take a seat. Number one, early in this trial, I asked both panels, to please tell the court how many witnesses you will present and how many pieces of evidence you expect to authenticate by the testimony of your respective witnesses. Both panels submitted their so-called compliance. That is to say, when a judge issues an order and you comply with the order, you file a piece of paper called compliance, and then you attach whatever it is that the court wanted to see or hear or to read. There's a compliance dated 27 January 2012, filed by the House of Representatives, where the order of the court was, list down all your testimonial and documentary evidence on my instigation. And I have this copy of the compliance by the House of Representatives. Number one, Article 1, partiality to Mrs. Arroyo in Supreme Court decisions. Testimonial evidence, 6 witnesses. Documentary evidence as appropriate. This is a long list of documents that these 6 witnesses were supposed to authenticate. Article 4, irregularities in the issuance of the status quo ante order on the impeachment proceedings of former Ombudsman Merceditas Gutierrez. Testimonial evidence, said the prosecution panel, 7 witnesses, plus the corresponding list of documentary evidence to be presented through those 7 witnesses. Article 5, gerrymandering in the creation of 16 new cities and the declaration of Dinagat Island as a province. Testimonial evidence, 3 witnesses. I'm quoting the prosecution panel. Documentary evidence, a list of cases. Article 6, allegedly improper investigation of Associate Justice Mariano del Castillo's plagiarism case. Testimonial evidence, 2 witnesses. Documentary evidence as listed. Article 8, failure and refusal to account for the Judiciary Development Fund and special allowance for the judiciary. Testimonial evidence, 7 witnesses. All these witnesses are listed here, what their names are, what their addresses are, and what is the purpose of their proposed testimony. Plus, of course, the documentary evidence to be authenticated by these witnesses. So, House of Representatives, January, tells us in the impeachment court, we'll present these witnesses, we will also prove and authenticate, introduce into evidence and authenticate documentary evidence. Now, all of a sudden, it's only March, January, February, March, all of a sudden, there's a complete turnaround. Ni hi, ni ho, wala. Basta sabihin lang niya, ayaw na namin na presenta ng ebidensya. Ngayon, this is of very serious concern to me as a lawyer and as a former judge. Una, naglalaro ba? Nagbibiro ba kayo? In writing ang inyong compliance nga. Sabi niyo, will present so many witnesses, so many documentary pieces of evidence. Pagkatapos ngayon, sabihin niyo, without explanation, our case is very strong. We no longer want to present evidence on these causes of action. You are prejudging the case. What are you? Conducting trial by, what are you doing? Conducting trial by publicity? Let me remind you, an impeachment trial is both quasi-judicial and quasi-political. But let me place this in context. In its quasi-political aspect, an impeachment trial is not to be decided by the reading public or the viewing public or by any of the publics that we are addressing. It is true that the Constitution provides sovereignty resides in the people and all government authority emanates from them. But sovereignty resides in the people is a term of art in law, meaning to say it is a special code. It has a special meaning. It's not being used in its ordinary meaning. When the Constitution says sovereignty resides in the people, what people are we talking about? All 98 million Filipinos? Or all 65 million registered voters? A majority of registered voters? All survey firms? Or which survey firms are you referring to? Referenda? By certain NGOs? Referenda and surveys in certain campuses? No. This is not a direct democracy and we are not in Athens. The people are not going to decide this case. It is the Supreme Court and it is the High Court of Impeachment, this Senate, and the Senate alone that will decide this case. We are going to hold ourselves immaculate of all the propaganda that you are distributing abroad, meaning to say outside of this courtroom. Mapropagadize kayo sa gusto ninyo. Walang epekto yan. Ngayon, hindi naman ito, as I said, hindi ito direct democracy. Representative democracy ito. We, the impeachment court, are the representatives of the people. We have been chosen by the Constitution to exercise the sovereign powers of the sovereign people in making a decision on the impeachment trial. Kaya galang naman ninyo kami. When I heard this news yesterday, I felt like creeping back into bed and adopting a fetal position, which is the normal reaction of any sane person when he is faced with a world that is crumbling around him. I no longer know what universe I am in, because I've spent 5 years of my miserable adult life in trial court day after day after day, hearing civil, criminal cases, and special proceedings. But I've never seen this done to a judge before. Ngayon, first point of concern was the compliance of the House of Representatives telling us that they were going to present such witnesses and such documents under these articles, but now they are being withdrawn or being dropped. At the outset, my request is prosecution files the written motion as directed by the Senate President. Will you please verify, are you withdrawing the articles, or are you just waiving the right to present evidence on them? There's a difference. If you're withdrawing the articles, then you have to amend your complaint, because under the rules of court, you have to amend your complaint to conform to the presentation of evidence. Di pala kayo mag-ebidensya, ba't nyo lilistan yan? On the other hand, if you're completely just waiving the right to present evidence, then you give the defense the right to present evidence, even if you have already waived your own right. Just because you waived your own right does not mean you can waive it for the other side. You've already, in effect, raised suspicions in the mind of a reasonable person about the moral position of the Chief Justice. Of course, they have a right to present evidence to dispel those suspicions raised by your own complaint. Kaya, pakiliwanag lang. Kayo ba ay sinasabi nyo sa amin, ayaw na namin itong articles of impeachment at baliwala na, pakibasura na. O, nandiyan pa rin yan sa aming complaint, pero ayaw namin magbigay ng ebidensya. Will you please make a distinction between those two? Because each of those optionals have their own peculiar circumstances in law. Ngayon, nagbasa na ako ng mga sinabi ninyo noong Enero lamang. Para so pala ngayon, nagkapalit na kayo ng isip. I am very concerned that this might constitute unethical behavior. In trial court, we have also a term of art called, which sometimes used, and it is normally runs to frivolous and sham. Frivolous and sham is not to be taken its ordinary meaning. It is also to be taken its technical meaning. And this is a technical meaning of a frivolous claim. A frivolous claim in legal terms refers to a lawsuit or motion in lawsuit motivated by an intent merely to harass, to delay, or to embarrass the opposition. In order to be found frivolous, the claim must have no arguable basis in law or in fact. Ngayon, let me remind you, prosecutors of the prosecution panel, of your code of professional responsibility, kung abogado kayo, Canon 10, a lawyer owes candor, fairness, and good faith to the court. Nang sinabi niyo sa compliance niyo, napipresenta kayo ng ebidensya at bawat testigo ay maglalabas ng mga dokumento niya. Were you in good faith? Because now you turn around and say you don't want to do that. Canon 10, a lawyer owes candor, fairness, and good faith to the court. Rule 10.01, a lawyer should not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. You've been misleading the court. There are some senator judges who, as a matter of personal discipline, read well ahead of the two panels. So if you present a complaint with us for impeachment with 8 articles, there are some lawyers among us who will read for all 8 articles. That's what the law calls frivolous. When you later say, I don't want to present evidence on 8, I only want to present evidence on 5. Plus, let me remind you, gentlemen, the lawyer's oath. I will do no falsehood, nor consent to the doing of any in court. I will not nothing about it. You are engaging, gentlemen, in a public discourse on the merits of your case. You're not supposed to say that at all. Ang yayabang ng mga nagsasalita na ganyan, ang gago naman. Ay, my goodness. Ang kakaguhan is a ground for contempt of court. Another case, Philippine-British Company, V. de Los Angeles, 1975. By failing to substantiate his serious charges when called upon to do so, a lawyer may not only show his dubious motive, therefore, but the falsity of the charges as well, which merits disciplinary action against him. Eh, pero yung tatandaan na ninyo eh. Nilista kayo sa amin, naka-robe kami at lahat. We look like a convention of undertakers every day. Coming here in these robes, you're supposed to grant us full and high respect. You cannot give us a list and then after a few months say, oh, I'm sorry, but I've decided to change this list. You can't do that to a court that you respect. Again, the Code of Personal Responsibility, Canon 12, a lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Case, Pepsi-Cola Products v. Court of Appeals, 1998. As officers of the court, lawyers have a responsibility to assist in the proper administration of justice. Hindi ito politika, gentlemen. We are not in politics, where you are free to hire character assassins and do all manner of dirty tricks. This is a quasi-judicial proceeding. Itigil na ninyo yan. Yun ang problema nyo eh. Mahilig kayo sa ganyan eh. You're very fond of the occult arts. As officers of the court, lawyers have a responsibility to assist the proper administration of justice. They do not discharge their duty by filing pointless petitions that only add to the workload of the judiciary, especially this court, which is burdened enough as it is. A judicial study of the fact and the law should advise them in a case such as this should not be permitted to be filed to merely clutter the already congested judicial dockets. They do not advance the cause of the law or their client by commencing litigations that, for sheer lack of merit, do not deserve the attention of the court. That was the Supreme Court speaking in all those cases. Were you aware of these decided cases when you decided on your own to make that manifestation yesterday? That was my second point. The first point is, you filed a compliance and you listed, according to the instruction of this court, your list of witnesses and documentary evidence for every article. And now you've got turn around and say, oh no, we've changed our mind. That can be a very expensive change of mind. Second point of concern, that might be an ethical behavior. I have never seen such a parody of justice in my entire adult life in the judiciary. I remind you, for those of you who have been talking to your character assassins, I've been awarded as a judicial judge for excellence in trial work, not only by the TOYM of the JCs, the TOWNS of the Lions, but many other NGOs, whom I will no longer enumerate. Kaya siguro may alam akong konti tungkol sa batas. Huwag nyo kaming ginaganyan-ganyan. Last and most important, I will not be able to help it if the members of the impeachment court will engage in the judicial and legal presumption that evidence willfully suppressed would be adverse if produced. Kayo mismo ang nagdala nito You called up this disputable presumption when the defendant refused to give his consent to the opening of his dollar accounts. You said evidence adverse, evidence suppressed is evidence adverse. Kung ayaw mo ipresentang ebidensya, ibig sabihin, kung walang ebidensya pang dagdag, na may tinatago ka. Yun ang sabi niyo sa Chief Justice. Ngayon naman ang ginagawa niyo. Sinabi niyo na 8 articles of impeachment nyo. Ngayon, ayaw na ninyo maglabas ng ebidensya nyo sa 5 of those 8 articles. Then let me invoke the disputable presumption against you. The rules of court provide disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. Letter E, that evidence willfully suppressed would be adverse if produced. Ngayon, ano kayang ibig sabihin ng teknikalidad na yan? In People v. Padrigona, 2002 case decided by the Supreme Court, the court said, this rule that evidence willfully suppressed would be adverse if produced does not apply if, A, the evidence is at the disposal of both parties. Yung ebidensya ba ninyong nilista ninyo sa compliance ninyo ay pwede nyong ibigay doon sa defense? That is the only exception. Another exception, the suppression was not willful. Willful ito kasi kusa nyong ayaw nyo Wala namang supervening factor that prevents you from presenting your evidence that you already said to us in January you are going to present. Letter C, this merely corroborative or cumulative. This does not apply because when you file an impeachment complaint, you have different articles of impeachment which are separate from and independent of each other. So none of these articles of impeachment, just like causes of action in a civil case, are said to be cumulative or corroborative. Cumulative means you already produced evidence in the form of one witness, and you just want to add, let's say, 10 more witnesses to completely repeat what that other witness said. That is corroborative. Kaya, kung corroborative lang witness mo, pwedeng hindi mo na ipresenta. Ito naman, hindi corroborative because they are separate and distinct articles of impeachment. And letter D, the suppression is an exercise of a privilege. Kaya yung defendant, sa bank accounts niya, ayaw niyang magbigay ng consent niya. But we cannot apply this presumption to him because the suppression is the exercise of his privilege. That is a privilege given to any person who opens a dollar bank account. The law provides confidentiality is absolute except only when the depositor is giving his consent. Ngayon ito, kaiba itong inyong kaso na ito. Wala kayong privilege When you file an article of impeachment or a cause of action, it is not only your right to present evidence, it is also your duty. It's not a privilege that you can just waive at will. That is not what the law means by the suppression is the exercise of a privilege. You have no such privilege to bother the court. Cases, People v. Melo Santos, 1995. The prosecution evidence must at all times be competent and admissible to sustain its stand. The prosecution cannot rely on an imaginary person charging a serious offense without extending to the accused the benefit of confronting his accuser. In default of a satisfactory premise for the non-presentation of a crucial witness, it ineluctably follows that disputable presumption that evidence deliberately withheld would be adverse if produced remains undisturbed. May tatago kayo Takot ba kayo? Kayo ang sinasabi nyo, panalo na kami dito sa tatlo. Kami ang magdesisyon yan, hindi kayo. Ang yayabang nyo. Maaga pa. What are you, conducting trial by publicity? Is that what you're trying to do? We will not be swayed. The entire capacity for tsunami waves by Manila Bay can fall over this impeachment court and will not be affected by what you say in the public or what your chosen public brings back to you, particularly if they've been paid to do so. Please, do not try these little dirty tricks on us. We're all old people here. Tumanda na tayo lahat sa politika, huwag nyo kaming ginaganyan, ha? Kamukha ng survey, just as I predicted. Aba, may balita kanina sa isang dyaryo. Nang survey daw sa UP, 500 ang respondents. At like 75% of them said, no, we no longer trust the Chief Justice. Kayo mga UP kayo, dapat kayo i-kick out immediately. If you are true, actual persons, you should be kicked out immediately. Because you do not deserve to be in UP, and the people who machinated the publication of that press release should likewise be kicked out of UP. If they're enrolled in the rolls of the university as alumni, they should be permanently erased from the rolls as a perpetual shame on the university. Pero mo, may survey daw sila na 500 katao sa UP nagsabi ng Chief Justice so far because of the prosecution evidence can no longer be trusted. Ang taas pa naman ang pagtingin ng tao sa UP, pagkatapos 500 lang out of, let us say, 50 million all over the Philippines, and it's not even conducted on scientific basis. It's not conducted by any of those reliable survey firms that have already been proven in their forecast for election results. Kanya-kanya lang sila. Grabe. My goodness me. If I were the symbol of UP standing there, naked, called the oblation, I would immediately throw away my fig leaf. Huwag na tayo magtago-tago pa. Kagaguhan lang naman palang pinapag-aralan sa UP kung ganyan. I cannot imagine a survey where 500 high IQ people will say, we have already lost trust in the Chief Justice because we have already heard the evidence from the prosecution, although we admit that the defense has not yet presented its case. Grabe naman. Sino namang PR firm nag-isip nito? Sabihin lang ninyo, hanapin ko yon. You are playing games. I was not born yesterday. I was born a long time ago and I'm about to die. I want to leave a legacy that at least when presented with this anomaly in trial technique, I rose to condemn it. We will be studied generations from now by other senators faced with other impeachment cases, and I do not want the records to reveal that we allowed this development to pass by uncommented on. This is a travesty. Una sabi nyo, malakas ang ebidensya namin kasi 8 ang krimen niya. 8 ang articles of impeachment namin. Bilangin mo, 8 yan. Pagkatapos ngayon, 2 buwan pa lang, wala na. 3 na lang sa 5. Kasi tama na yun, panalo na kami. Wah! I request the Secretariat should record in our journal that I said, wah!
Silence. Silence, please, silence. Majority Floor Leader.
Thank you, Mr. President. Senator Osmeña is asking what is the spelling of wa?
That's an expression.
Mr. President, again, may I maybe call on the prosecution, find out what is the pleasure concerning the manifestation that they made yesterday?
Good afternoon, sir. Your Honor, Mr. President.
What's the pleasure of the distinguished gentleman from Iloilo?
Your Honor, as was manifested yesterday by the prosecution, that after the cross-examination conducted by the defense, we are terminating the presentation of our evidence.
Are you not, according to the newspapers this morning, the prosecution intends to present the Honorable Justice Maria Lourdes Sereno. And I also read in the newspapers that in the resolution of the Supreme Court and Bank, I think it was yesterday, the Supreme Court and Bank left it to the discretion of the good Justice Maria Lourdes Sereno to appear here voluntarily for the prosecution. And I remember that one of the panel of prosecutors, I think it was attorney Congressman Colmenares, who informed the court that he wrote Justice Sereno to appear here for the prosecution. And I think the court is entitled to know whether you are still you still intend to present Justice Sereno.
Your Honor, a letter invitation suggested by this honorable tribunal was delivered personally to the office of Justice Sereno last Monday for her to appear before this honorable tribunal tomorrow. That's a Thursday.
Tomorrow?
Yes, sir, but we have not yet received any formal communication or reply from the Lady Justice of the Supreme Court.
Yeah, incidentally, I raised this question because I am interested to know your real position. Because yesterday you already terminated, according to you, to the records, your presentation of evidence on Article 3 and Article 7 that you have retained among the 3 articles of impeachment out of 8 articles of impeachment covered by your pleading known as articles of impeachment. And I ask you very definitely whether you're really going to stop presenting any more witnesses on this 2 articles. And you said yes, that's my recollection, except that you reserve the right of the prosecution to present evidence on Article 2. And I understood that. I was of the mind that you were referring to the pendency of a case in the Supreme Court regarding the foreign currency deposit.
That's correct, Mr. President. We reserved that right yesterday.
Will you clarify really the position of the prosecution?
After yesterday, Mr. President, the prosecution met and we discussed about the pending invitation to Justice Sereno. That's why today we would like to make that manifestation that the prosecution is trying to get in touch with the Honorable Lady Justice of the Supreme Court if she is indeed willing to testify, and that if we may be given time within the week, we will communicate to the Honorable Tribunal if the Lady Justice would be willing to testify, which means, Your Honor, that we would like to reserve a right to present her if she's willing.
You are not really closing your evidence. It's open.
We are, Your Honor, we are already terminating the presentation of evidence with the 2 reservations. Number 1.
You cannot make any reservation. If you cannot close your evidence, if you still have to present witnesses. The proper thing to do is to ask for continuance.
If Your Honor, please.
What's the pleasure of the...
Yesterday, I thought we were agreed together with the Honorable Court, Your Honor, that the enumerated impeachment articles, Your Honor, that were not touched upon will be considered as abandoned or dismissed. Not only because...
As far as the Article 1, Article 4, 5, 6, and 8. 5.
That's correct, Your Honor.
That's already effectively withdrawn.
Yeah.
That is That is clear. I clarified that yesterday.
And we were merely discussing, Your Honor, the modality or the means by which the same could be effected. There were some suggestions that a mere notice will be more than enough. We were of the impression that a motion to dismiss is necessary because there is already an answer filed, and as in fact there had been trial going on. So that matter of how to dismiss the four impeachment articles, Your Honor, will be effected is left to the discretion of the prosecution, Your Honor. But now comes another development, Your Honor, with this lot of reservations and so on, calling the Chief Justice Sereno to the stand. Maybe is another turning back from the original position that was manifested by the Chief Prosecutor before this Honorable Court, Your Honor. We just invite the attention of the Court on that matter, Your Honor.
Yesterday I clarified. I think the records of these proceedings will bear me out. Whether there's no question about the 5 articles withdrawn. That's clear in the record. And it was also clear to this presiding officer that the prosecution was terminating the presentation of its evidence with respect to Article 3 and Article 7. In fact, in the case of Article
2, 3, and 7.
3, Article 3, they did not only manifested that they were terminating the presentation of evidence, they cut down the allegation. They retained only in Article 3 flip-flopping. But as far as the entanglement with of the defendant with the former President, Madam Mrs. Gloria Macapagal-Arroyo, as well as talking to litigants as a basis of their charge that he did not follow the stringent requirement of probity, integrity, competence, and independence. They have already also withdrawn that. They have also decided to take that out and do not present any evidence on it. So, but they made a reservation only with respect to Article 2. And that is because there is a pending case, and understandably, the court was aware of that, because there is a pending case in the Supreme Court whether impeachment is an implied exception to the confidentiality of foreign currency deposits. So I would like to be clarified.
Mr. President, we are sticking to our earlier manifestation that we are we are terminating the presentation of our evidence subject to one reservation. And that is, the reservation is with respect to the dollar accounts of the Chief Justice.
Only.
Yes, sir.
And you are not going to ask Justice Sereno anymore?
No more.
Right. So,
and I just want to make a manifestation that yesterday, my math was wrong. When I stated that with respect to the documents that we have marked so far, 166 documents for Article 2, 16 documents for Article 3, and 65 evidence, but it was just 247. So 247 documents, Your Honor. And also, Mr. President, what we manifested and what we stated even outside of this honorable tribunal with respect to the termination of the presentation of evidence was that we felt that we have already presented a strong case.
All right.
And even when we, even outside this honorable tribunal, Mr. President, we're saying that it is really up to the tribunal to decide, to appreciate. And we're just stating our advocacy without prejudging the outcome of the resolution, because we have high respect to this honorable tribunal. We just want that to make, we just want that to put on record those statements, Mr. President.
All right. We accept that explanation. Now, what is your pleasure? When are you going to make your offer of evidence?
We are now...
especially documentary evidence.
Yes, documentary. We are now requesting the honorable tribunal through the honorable presiding officer to give us the prosecution until Friday this week. That's 2 days from today, within which to...
3 days. 3 days.
Yes.
To file...
To file our written formal offer of documentary evidence.
Yes, and list them down.
Yes.
And then we will also give the defense enough time to go over it with copy furnished. Huh?
Yes.
We will do that, Mr. President.
May we request, Your Honor, if it is not asking too much, a 5-day period within which to signify our objection and or conformity to the offer that
All
will
right.
be made.
That's a reasonable request. So when you file your pleading to formally offer your documentary evidence, testimonial documentary evidence to this court in writing, not send a copy to the defense, and the defense will have 5 days
From receipt.
from receipt of that, of your
Formal offer.
formal offer in writing to file their objection to your documentary evidence.
Mr. President, we will submit our documentary offer of evidence, documentary evidence on Friday. Friday this week, that's 2 days from today. And we understand that the Senate has set a caucus also on Monday. Probably it will be reasonable, Mr. President, that to ask the defense to submit it also, if not 2 days, 3 days. For us, we will submit it 2 days from today.
Yeah, but
and if I may finish, in fact, there's already a submission of the suppression of evidence with respect to Article 2.
You know,
and 166 documents pertain to Article 2. So we're just adjusting, Mr. President.
Just a minute. You know, for the prosecution, all you have to do is actually to list these documents in some pieces of paper and list them down. But the defense, to be fair to them, they'll have to analyze what those documents are and to state their objections for their admissibility. So 5 days is a reasonable time.
We submit, Mr. President.
So ordered.
Thank you, Your Honor.
Now, when will the defense start its presentation of its evidence in chief?
We will await the ruling of this court, Your Honor, after the order is made relative to the admissibility of the offered evidence, Your Honor.
To expedite the proceedings, would it not be possible to start the presentation of the testimonial or whatever evidence the defense would make and then we will deal with the objections of the defense on the offered evidence of the prosecution?
Your Honor, please, we wanted to do that, and by way of accommodating the court, in order that the general public may not have the impression that we are delaying the proceedings in this case, Your Honor. But there are so many things that may come up, Your Honor, in our opposition as against the admissibility, for instance, of these documents, Your Honor. insofar as the prosecution is concerned, these evidences are with them. They have examined it. They have made a formal offer of the same. But insofar as the defense is concerned, Your Honor, we have to analyze it is not enough that they are listed as being offered. We have to analyze what is the purpose of the offer. They may be admitted on certain grounds, Your Honor, but decidedly they may not be admitted in consonance with the purpose for which they are offered. That is our position,
right.
Your Honor.
Mr. President, if we may,
Yes.
we are constrained to object to that proposal, because if we will submit
What
our
proposal?
the proposal of
the chair.
No, it's not the chair's proposal, but the proposal of the defense to submit or to present their evidence only after the ruling of the Senate on the admissibility, if I may finish.
Yeah, that is the most...
If I can.
Go ahead, I'm
have
sorry.
the floor. Thank you. Because if that is so, Mr. President, we asked for 2 days to submit our formal offer of evidence, and that will be Friday. And the chair gave 5 days to the defense. And if you count that, it would be Wednesday. And from tomorrow until Wednesday, if we will follow the proposal, there will be no hearing. And to us, it is a waste of time of this honorable court.
Many times,
Mr. President, that is the position. That is the position of the prosecution.
Your Honor, please, many a times we have been over-liberal and magnanimous to the prosecution, Your Honor. They come here, no evidence, no witness, the case is, the setting is postponed, Your Honor, and we had never been heard to complain, Your Honor. We had been very accommodating. Now, if they wanted a very strict application of the rules, we will meet them on head-on, Your Honor.
But Mr.
Well, there are various evidence here presented, documentary at that. If they are overruled, and they are rejected, why are we going to touch them in the presentation of our evidence, Your Honor? On the other hand, there is even a motion filed by us to suppress and or to delete from the record, Your Honor, the documentary evidence consisting of bank records, which we feel are in violation of the rule on regarding privacy pursuant to Republic Act 1405, Your Honor. Why will we be deprived simply because you wanted us to go the way you wanted to? There is nothing that the prosecution can impose upon this defense, Your Honor. We've never been unreasonable.
Sir, I just have to respond to that. There's a statement.
Yes,
with respect to the prosecution not being prepared, to the prosecution not ready, and to me that's uncalled for. To us, just want to put on record, Mr. President.
I'll stick on the record of making
It's
that
okay
statement,
if you
Your
stick on
Honor.
the record, but Mr. President, we want to put on record that that is unfair, inaccurate statement.
Well,
And we submit to the discretion of our honorable presiding officer.
all right. We cannot control this court cannot control the prosecution as well as the defense regarding their presentation of their respective positions on this impeachment trial. The defense is entitled to a reasonable time to prepare and assemble their evidence in order to present it orderly before this court. So, how many days after do you need to prepare for trial for the presentation of your defense?
We have left that to the discretion of the Honorable Court, Your Honor. If after a ruling had been made, we are so ordered to present our evidence anytime, we will, Your Honor. We will abide very willingly.
We will work fast to make rulings on the offered the evidence by the prosecution. So be ready.
Thank you, Your Honor.
Be ready.
Thank you, Your Honor.
Including the motion of the defense to exclude certain
documents,
the bank documents that floated around. So that's understood that you will file your written offer of your evidence formally to this court not later than Friday.
We will do that, Mr. President.
And then from the time you notify the defense of the filing of your written offer of your evidence to this court, then they will have 5 days also, not more than 5 days, inextendable, to submit their objections. So ordered.
Thank you, Your Honor.
When will be the hearing? Your Honor, may we inquire, when will be the hearing, if that's the case, Your Honor? Can we set at least a tentative date so that we can also prepare, Mr. President?
Mr. President. Mr. President.
The majority floor leader.
Yes, may we give the other members of the court the chance to decide on this on Monday, Mr. President, during the caucus,
Yeah.
to answer that particular question?
I suggest that both sides must be ready every day for trial. You see, I am sure that you have prepared this case very well on your parts, so that there's no need to appear being taken by surprise because we are going to call the case for trial at any given day.
Mr. President, yes, we are ready, but every day. But may we be clarified if we have a hearing on Monday, if that's the case?
No.
Because they were given 5 days, which will end on Wednesday, Mr. President.
Yes.
Just for the clarification of the prosecution,
Well,
Your Honor.
Mr. President, at the rate things are going, I don't think we will have a trial on Monday.
So when will be the earliest, at least a tentative?
March 12, according to the clerk of court.
March 12, Your Honor?
Yes.
March 12. March 12. Next Monday.
Because Wednesday is a 7, I suppose. Wednesday, Your Honor, is March 7.
We will be ruling on the offer on or about March 8th, which is a Thursday. And that is the reason why Monday is the most practical date, March 12th.
We submit, Mr. President.
So the next trial date will be at 2 o'clock of March 12th in the afternoon. 2 o'clock in the
meantime,
afternoon of March 12th.
Mr. President, in the meantime, there is a question on whether the defense will be presenting their evidence already on March 12th, Mr. President. They should be ready. You should be ready to present on March 12th. Yes, they are. May we recognize Senator Escudero, Mr. President, and then Senator Santiago, then Cayetano, or Miriam, Senator Miriam Defensor Santiago, as we
The
recognize
lady
first.
senator from Iloilo.
Thank you, Senator Escudero. The prosecution will be making an offer of evidence and then it will rest. What all this means is that after it makes its formal offer of evidence, the prosecution will then lie down in front of that first table, face down on the floor, and assume a planking position. To go rigid there. That is called planking. Because tapos ka na. Para ka nang namatay. Huwag ka nang nagsasalita pa. Tapos ka na eh. Ngayon na ako nakarinig ng we are resting our case, we are making a formal offer, we are resting our case with a reservation. Pag sinabi mong resting your case, tapos ka na. That's an oxymoron. To say that you're resting and yet you'll come alive at a certain point at your pleasure. That cannot be done. Hindi ka ba nag-trial notebook? Alam mo naman na gusto mo pala magpresenta ng isang testigo, ba't di mo tinanong noon pa? Ganon yun. To be able to deserve your appearance fee, you have to prepare for every appearance in court. Eh ngayon, pantayin mo kami ng testigo mo. Masyado ka naman swerte sa buhay, hindi ginagawa yan in law practice Ngayon ako nakakarinig itong mga milagro na ito. Maybe it is correct. Climate change has already changed everybody's heads. Because I feel like I've just been confronted by a sinkhole. I've never heard this concept before in trial court. At hanap buhay ko yun, araw-araw yun. Sari-saring sinungaling narinig ko. Yun ang hanap buhay ng judge Mapo ka doon alas 8:30 hanggang alas 12:30, makinig ka ng sinungaling na parehong grupo. Kaya, magdesisyon kami sa impeachment court. If you are going to be allowed to rest, but without your reservation, or if you want to file a motion for everything to be suspended while we wait for the pleasure of your witness, which is unheard of in court. It is an oxymoron to say, Your Honor, we will make a formal offer, then we will rest, which is pursuant to the rules of court, but we will rest with a reservation that we will call on our witness when she is ready. And all of you, honorable men and women, ladies and gentlemen of the impeachment court, have to wait for her pleasure and the pleasure of the prosecution. That's in effect what you are asking us to do. Ba't ninyo hinanda yan nung Enero? Kung yun palang testigo ninyo. Ay, kayo naman, oo, nagbibiro kayo. You gotta be joking. Pagkatapos, it will take us so much time to make our offer of evidence. Wah! For the second time. Wah! Round 2. Kasi, basahin mo lang ang Senate Journal, nandiyan ang verbatim. No offer mo of evidence. Every time you present a witness, you say, offer her for the purpose of this and that. And we will authenticate certain documents with her testimony. Nandyan yan, di kopyahin mo lang sa Senate Journal. Anong problema mo? Have you never been in trial court? If so, can you please make way to somebody who has been in trial court before? That's not a big deal. Andyan na yan sa Senate Journal, kopyahin mo lang yan. And besides, you should have had a trial notebook kung saan nililista mo yon. Dahil alam mo na abot tayo sa puntong ito. Ngayon gusto nyo, mag-antay kami. Bakit is it going to tax your IQ so much that you need until Friday to make this? Dapat araw-araw yan, ginagawa yan ng secretary mo o ng clerk mo. It's all a question of just instructing her. Kopyahin mo ang Senate Journal, ano bang pinag-offer namin kanina? At para pag formal offer na, handa na tayo. In trial court, we don't even wait. We don't even wait for a period of time for the party to make a formal offer. Pagkatapos ng lista ngayon, bukas sabihin ng judge, mag-offer ka na. Dahil ginagawa mo yun throughout the course of the trial. What is the big deal about this? And it's highly clerical. We are only going to murmur there. Here is our witness. We offer the testimony of this witness letter A for the purpose of so and so. And these were the documents marked during her testimony, so and so. And we'll be spending the whole half day doing that kind of thing. So, this means only that either you don't know your rules of court or you're expecting or hoping for miracles to happen. Korte ni Milagrosos ito. You're waiting for a miracle to happen. Trabaho mo yan habang the trial is going on, lilistahin mo kung anong mga ebidensya mo, basahin mong sa Senate Journal, araw-araw yan, nandiyan yan Pagkatapos itong arte pa ninyo, pag nag-objection ng the other side, sasabihin ka, I make an offer of proof, Your Honor, or we make a tender of excluded evidence. You do that so that the appellate court can see the records and can determine if the ruling of the trial judge was correct or not. But there is no court higher than the impeachment court. That is the express language of the Constitution. The Senate, as an impeachment court, tries and decides. So there's no point making an offer of proof or a tender of excluded evidence because no one is going to read those documents. I already implied that before, but now I'm saying it explicitly for full understanding of what is involved here. These are clerical. These are ministerial functions. Bakit ang dami na inibali ko ang defense? Mag-make siya ng motion? Dahil, ngayon pa lang niya naintindihan, having placed these things in context, kung dapat ipa-admit yon o hindi. Nag-object na nga siya noon. Pagkatapos, hindi pa iyon. Alam naman natin, gentlemen of both panels, that the general rule is, in case of doubt, admit the evidence. Ganun naman yun Kaya let's not make a big deal out of these offers. Every time a witness is presented, one of you stands up there and says, if the Honorable Court will please, we'll offer this testimony by Mr. X, and we'll mark the following documents for the purpose of. Nag-recite na kamo niyan noon, tapos ulitin pa ninyo. Eh, yun lang eh, pang kahirap-hirap ninyo. Ay, sus Mariusek, where are your neurons? Where are your synapses? Your brains are very, very dark. You know, when you use our brains, the electrical impulses from one neuron jumps to another neuron. That is called a brain activity or a brain wave. Ngayon, kung may brain wave ka, lahat ng utak mo, kumikislap. It's entirely lighted. Ngayon, kung madilim na madilim ang utak mo, your neurons are not working. You are flatline. Meaning to say, hindi ba? Kung buhay pa ang pasyente, naka-jump up and down ng kanyang recording instrument. Pero kung namatay na, nag-flatline na. O, yan ang nangyari sa inyo. Nagpa-flatline na kayo. I am, please, appealing to you. Can you please prepare on the rules of court? I'm very underwhelmed by all this debate about how many days to give. Dapat ngayon pa lang, anda na kayo. Wah! Part 2.
Senator Escudero, Mr. President.
Majority Floor Leader.
May we recognize Senator Escudero, Mr. President.
Mr. President, ilang paglilinaw lang po kaugnay sa mga naganap kahapon at ngayon. May I address some questions to the Chief Prosecutor or any of the lawyers for the prosecution. Your Honor, kahapon tinanong kayo ng presiding officer kung wini-withdraw ba ninyo yung articles of impeachment, particularly 1, 4, 5, 6, and 8. And the presiding officer asked you to submit a manifestation or motion to that effect. May we know if that is forthcoming?
Yes, Your Honor, we have already a draft of our manifestation, and we will file it by Friday, Your Honor.
To clarify, Mr. Presiding Officer, Your Honor, iba ho yung withdraw sa hindi na kayo magpepresenta ng ebidensya. Ang sinabi niyo sa records kahapon, you are dropping it, you are withdrawing it, you are no longer presenting evidence. At some point you said that. May I know which one is it? The difference, Mr. President, Your Honor, is if you are withdrawing it, that means hindi namin pagbobotohan yung 8. 3 lang ang pagbobotohan namin. If you are merely not presenting evidence, nothing bars the defense from presenting evidence on all 8, and we will have to vote on all 8. May I know your intentions?
With that clarification, yesterday we said that we are withdrawing the other articles, namely Articles 8, 1, 4, 5, 6. And we will file a manifestation to that effect.
So you're withdrawing it?
Yes.
Meaning your intention is parang wala na yun dun sa complaint?
That's correct.
Given that answer, Mr. Presiding Officer, I have more questions to ask. One, that is in effect amending the complaint. By withdrawing certain allegations, in this case, articles.
Effectively, actually, they're waiving already the
Mr. President,
5 articles of impeachment, in effect, or abandoning it, if you,
Mr. President,
if you want to use to.
if I may, that was what Congressman Agabao said with respect to Article 3, that they are standing on the testimony of their lone witness and that they will no longer present evidence on the matter and that they are solely relying on the allegations of their complaint insofar as Article 3 is concerned, plus the testimony of the witness. In this case, it is not a mere abandonment, it is a withdrawal. Because, Mr. President, Your Honor, the issues have been joined with 8 articles already. Now, there is a manner and procedure by which a complaint or pleadings can be amended. And in this case, since the issues have been joined, by leave of court. So, again, may I clarify? So it's withdrawal of the 5. So we won't have to vote on the 5 anymore.
That's the position of the prosecution. No need to vote on the 5 other articles.
That's clear.
And our position, Mr. President, is that there's no amendment to the complaint. We are simply waiving a right to present evidence and, in effect, abandoning
Mr. President, Your Honor,
You
But
are not
with
only
respect-
waiving a right to present evidence, you have no more right to present any
Yes, we have no more right. We're abandoning it.
evidence. Yeah, abandon.
Abandoning, surrendering, withdrawing, dropping. Mr. President, may I know, again, this is for future impeachment processes. I hope it will not come anytime soon. But may I know, did the prosecutors consult with the complainants of the case? Because this is a substantial amendment with respect to the articles of impeachment. And I heard the good gentleman yesterday when he was interviewed, he said he consulted with the Speaker of the House. May I know, because the prosecutors, the 11-man prosecution panel, merely represent the 188 complainants. In other jurisdictions, even a mere postponement of trial, the prosecutors consult the House. In this particular instance, may I know if, and they pass a resolution to that effect, may I know if there is such a procedure taken or undertaken by the panel of prosecutors?
If it's a formal consultation with the 188 signatories, we did not. We consulted, for the record, the Speaker of the House and the Majority Leader, and we were given full discretion, blanket authority on how to present the case. It's a prosecutorial discretion. We're given that discretion, and now we are waiving a right with respect to the 5 others, and we're sticking, as the Senate President puts it, we will stand or fall on the 3 articles, namely Articles 3, 7, and especially 2.
Mr. President, I do not wish to debate nor argue with the distinguished Chief Prosecutor, only to place on record that the withdrawal of articles of impeachment is a substantial decision, and to my mind, it's not merely prosecutorial discretion. Perhaps what evidence to present, which witness to present, is prosecutorial discretion, but the 8 articles were verified by 188 congressmen. They swore that they had personal knowledge or based on documents that they read it, and that they are therefore accusing the Chief Justice of all 8 acts and or omissions. My fear, Mr. President, Your Honor, is while the prosecutor, Chief Prosecutor, considers this as a mere dropping withdrawal, but it would still constitute, in effect, an amendment of the complaint, which might present several other complications that we might not be prepared to encounter and face, given the problems we've been seeing in connection with this trial. I just hope that that can be clarified in your motion and manifestation that you will file, Your Honor, so that everything we do here can be used as a good precedent for future impeachment cases and students of the law. Thank you, Mr. President. Thank you.
Mr. President, we will clarify that in our notice manifestation.
Yes,
and we would like to thank Congressman
may I suggest
Senator
may I
Jesus Cordero.
suggest to the prosecutors to make a very simple, clear, and absolute statement withdrawing or abandoning whatever term or semantical terminology you will use to describe what you're doing without any further consideration, including presentation of any iota of evidence on this withdrawn articles of impeachment.
Mr. President,
Yes. No, I just want to know the reaction of this.
We will do that, sir.
All right.
Mr. We will make it very, very clear.
Yes. Okay.
Mr. President, may we recognize Senator Alan Cayetano?
Mr. President,
Kanina
kanina po,
minority floor.
nabanggit ng Chief Prosecutor ni Congressman Tupas na sayang yung time ng court kasi kung matagal pa yung hearing. Well taken po yun, but I'd just like to put on the record, hindi masasayang ang time kasi aside from giving the defense a fair chance to go over the submissions of the prosecution, ang daming problema ng bansa Kagabi lang, tumataas na naman ang presyo ng langis, di ba? So, may mga committee hearings naman na pwede kaming gawin at saka mga yung sa session, from problems sa economy, problema sa agrikultura, name it, we have it, and we'll be dealing with that. Ang question ko po, will the prosecution biniding time, or will they still reply kapag if and when the prosecution, the defense submits some objections to the, you will submit on Friday, tama po ba? Tapos sila Wednesday. So do you need time na sagutin pa yon?
Hindi na po. Pag nasubmit namin ng Friday yon, and we will submit it kung may opposition, then we'll submit it for resolution na.
Because we're assuming na sa Thursday, makakapag-decide na po kami para mag-trial na ng Monday. But there's a big possibility na kung marami pong i-bring up ang depensa, kung 247 documents yan, matinding review at saka pag-uusap pa ang gagawin namin. So I just wanted to know whether so submitted nyo na as far as you're concerned kung ano ibibigay nyo sa Friday. Then we will deal with their with their objections and then then the court will make the decision.
Tama po yun, Mr. President.
Thank you, Mr. President.
Majority Floor Leader.
Yes,
Mr. President,
The gentleman from Ilocos Sur.
may we
And then
request,
Senator
Mr.
Recto.
President, there was a statement here earlier made by the good lady from Iloilo referring to the prosecution as gago. Baka naman po pwedeng matanggal yon dahil baka hindi naman po maganda sa posterity natin na nababasa po yun na natawag po kami na...
No objection, Mr. President.
Thank you, Madam. Thank you, Mr. President.
All right.
Mr. President,
Strike the term G-A-G-O from the record.
Mr. President, may we recognize Senator Ralph Recto.
The gentleman from Batangas.
Thank you, Mr. President. Mr. President, just a clarification. I heard earlier that we come back on March 12. Is that correct, Mr. President? That means for 1 week next week there is no sessions.
We will resume the trial of this impeachment case on March 12 at 2 o'clock in the afternoon.
That is right. And that would mean, Mr. President, that we would have 2 session weeks left until March 23. Looking at the schedule of the impeachment court as well, and that of the Senate and the House of Representatives, we come back on May 7, if I'm not mistaken. And I've heard from the defense that they need something like 5 or 6 weeks to present their evidence in behalf of the defense.
We cannot deny them that.
Yes, I'm not denying them that, Mr. President. I'm just looking at the schedule of this impeachment court, and looking at that, then it is possible that we will not be through by June 7, Mr. President. Because we only have 4 session weeks left when we get back on May 7. So if we come back on March 12, we only have 6 session weeks left, Mr. President. Is it correct to hear from the defense that you would need something like 6 session weeks?
I have not estimated yet, Your Honor, because that will depend on the developments after the striking out or the abandonment of the 4 impeachment articles, Your Honor. 5 articles.
I only mentioned this, Mr. President, for the consideration of the impeachment court with regard to our schedule as well, so that all of us will know what is in store. So thank you, Mr. President.
Thank you also.
All right. The lady senator from Taguig.
Mr. President, this is just a follow-through on the concern raised by Senator Miriam Defensor Santiago and Senator Chis Escudero on the withdrawal of the 5 articles. Mr. President, I direct the attention of the prosecution to our rules of court, which have supplementary effect on these impeachment proceedings. Rule 10 on amended and supplemental pleadings clearly states that pleadings may be amended by adding or striking out an allegation. And this can only be done subject to Section 2 and Section 3, wherein Section 2 states that an amendment is a matter of right before a responsive pleading is filed. We all know that the responsive pleading has been filed, and therefore it is Section 3 that comes into effect, which states that the amendments can only be made with leave of court, except as provided in the next preceding section, substantial amendments may be made only upon leave of court. This refers to civil proceedings. If we will look at the rules on criminal proceeding, then I will make reference to Rule 110, Section 14, which states, amendment or substitution. A complaint or information may be amended in form or in substance without leave of court at any time before the accused enters his plea. After the plea and during the trial, a formal amendment may only be made with leave of court. So in both cases, Mr. President, whether you consider this impeachment proceeding as close to a civil proceeding or close to a criminal proceeding, both require leave of court. So I sincerely suggest and request that the prosecution takes this into consideration when they when they file the appropriate manifestation or clarification next week. Thank you very much.
Well, I just want to state this for the record and for the consideration of the members of this court as well as of the two panels of lawyers representing both sides of this impeachment trial. While we are a court of record, we are not really strictly a court that maintains a record for purposes of appeal, because there is no appeal in this case. And so therefore, we are blazing a new trail. Though the rules that were mentioned, in my humble opinion, are not applicable to this particular proceeding because there's no assignment of errors to be thought about for the future because there is no appeal lying in the decision of this court. Either we pronounce the respondent guilty or we say he's not guilty, and either side, no appeal lying. The end of the matter will be the verdict of this court. Unlike in an ordinary civil proceeding, civil case, or in a criminal case, if the defendant is convicted, he can appeal to a higher court and assign reviewable errors of the lower court. Or in a civil case, whoever loses in the civil case can appeal the case and assign reviewable errors in his appellate pleading. In this case, there is no appeal. So, whatever we say with respect to the evidence, with respect to the admissibility of evidence, ends there. They're recorded for reference purposes, but the verdict will be rendered by this court on the basis of the appreciation, final and ultimate appreciation of each of the members of the Senate sitting as judges, jurors in this. That's why I called it jurors, because each one of us will form a judgment of this case, of the respondent. Once that judgment is rendered, we count the number of votes that will vote in favor of acquittal, as well as the number of votes involving that will be in favor of pronouncement of guilt, and if it is guilt, whether we attain the two-thirds vote, which is an absolute 16 of all the members of the Senate. So all of these discussions are for our own guidance. But since there is no reversible error in this proceeding, because there is no appeal, we will take the bull by the horn when we reach the bridge, so to speak. Okay?
Thank you.
Your Honor, please.
Mr. President.
we understood the position of the Honorable Presiding Judge, Your Honor, but there seemed to be some plausibility on the statement made by the Honorable Senator Pia and Senator Miriam Defensor Santiago, Your Honor, because what is involved in their articulation, Your Honor, postulation, are merely rules of procedure, Your Honor, not on the validity of whatever judgment this court may render after trial on the merits. The issue that was posed a while ago is what mood must be taken, must be followed in connection with the non-discussion anymore, or non-taking into consideration of impeachment articles 1, 4, 5, and 6, and 5 articles, Your Honor. We have not yet reached that stage, Your Honor, where a judgment on the merits had been rendered. So, the way I understood it, because there is no definite rule in so far as this kind of eventuality is concerned, provided for under the rules of the Senate, Your Honor, then there is no harm adopting the rules of procedure enshrined under our rules of court. I fully agree. I fully agree, Your Honor, to the effect that if there is already an answer, meaning an adverse pleading, then a mere statement on record or an oral manifestation will not be enough for the dismissal or disposition of those abandoned articles of impeachment. Because the law requires, per procedure, Your Honor, that it must be subject to a motion and approval. A motion is not enough, Your Honor. Even a mere notice is not enough in my assessment.
Precisely, I made it clear that there will be no evidence being presented on those articles, and second, there will be no judgment on the pleading. If you remember, I asked that question from the prosecution yesterday. So, but I will not begrudge and take it away from the defense to use whatever material evidence they have with respect to Article 1, Article 4, Article 5, Article 6, Article 8, to be used for the defense of the respondent in meeting the assertions and the evidence presented to prove those assertions as far as Article 2, Article 3, and Article 7 are concerned. In other words, you have the advantage.
Yes, Your Honor.
You have a great advantage.
We are fully appreciable of the gesture on the part of this honorable court, Your Honor.
That's why I warned the prosecution that this is a fatal error that you are committing if you do not watch out.
Mr. President.
I don't have to teach pleading and practice here, but you think about it.
Yes, Your Honor.
Mr. President, one final member,
Yes.
Senator Jingo Estrada, please.
Senator Jingo Estrada has the floor.
Maraming salamat, Ginoong Pangulo. Isang katanungan lang po kay Congressman Tupas. Doon po sa winidraw niyong 5 articles of impeachment, yan ba ibig sabihin niyan ay hindi niya na ho ipa-file yan next year kung sakasakaling maabsuelto si Chief Justice Corona?
Mahirap po na tanong yan, Ginoong Pangulo, dahil wala ho tayong control dun sa ibang members of the House.
Alright.
So ibig sabihin, hindi ko po masagot yung katanungan ni Senator Jingo Estrada ng categorical.
Alright. Pwede malaman yung pangalan ng isang prosecutor dun yung kamerkana na itim? Yes. Sure.
Si Attorney Vitaliano Aguirre II.
I understand he's a private prosecutor.
Yes, sir. May he be recognized, please. Mr. President?
Yes, please.
Ginoong Aguirre, kanina ho, nung nagsasalita si Senadora Miriam Defensor Santiago, mulat sa poll, nung tumayo si Senadora Miriam Defensor Santiago, hanggang natapos si Senadora Santiago, ay nakalagay po ang inyong kamay sa inyong tenga. At para bagang ayaw niyo siyang pakinggan.
Totoo po
yan. Yan po ay isang kabastusan dito po sa isang miyembro ng hukom na ito. Kung yun po, kung kayo naman po ang nagsasalita at kami naman po ay gumanon, ano ho ang inyo mararamdaman?
Alam po, totoo po yun, sapagkat nasasaktan na yung tainga ko.
Alam nyo,
Mr. President, point of order.
What's the point of order?
I charge this private prosecutor with complaint of this impeachment court. I have the evidence right here, taken in a video by Senator Alan Cayetano. And to say, nasasaktan ng tenga ko, should have been cause for you to walk out of this courtroom with permission of the court. But you cannot make those contemptuous gestures in front of a judge and get away with it. I submit, Mr. President, that this should be taken up.
To be fair, I'll give the counsel a chance to explain himself.
Your Honor, kasi po, sinasabi ng kagalang-galang na hukom na ngayon lang daw po nangyari na ang isang complaint ay wini-withdraw or ng prosecution or ng sino man. Pero yan po ay natural po yan sa court practice. Nangyayari po yan araw-araw naman nagwi-withdraw ang isang abogado ng kanyang complaint or ng part na complaint nag-amend. But the fact, Your Honor, please, that this is the first time that I experience in my 40 years of practice na ang isang judge ay nagle-lecture sa mga abogado. Hindi po ata tama yung mga ganun eh.
bakit hindi ho kayo tumayo nung nagsasalita si Senadora Miriam para mag-object?
Hindi po ako, wala po akong karapatang mag-object sapagkat kung kailangan pong i-recognize muna ako ng kagalang-galang na impeachment court nito upang masabi ko kung anong nasasaloob ko. Pero nang nandito na po ako ngayon, di sasabihin ko po ang nasasaloob ko.
All right.
Mr. President, I reiterate my motion to cite for contempt by the impeachment court, not by me, but by the impeachment court. Imagine if all the lawyers did that in front of the impeachment court, if one of the senator judges took the forum to express his opinions. Kasi salungat sa gusto mo, kaya ayaw mo pakinggan. Kung ayaw mo pakinggan, umalis ka sa korte.
Aalis na nga po sana ako eh, kaya lang...
Granted! If that is in the form of a motion, go ahead! Nangahamon ka!
Aalis na po ako.
Dito ako nakaupo eh. Gaganyan ka sa akin?
May I suggest that...
And it's on video.
May I suggest that let us be calm in this proceeding and deal with one another in a fashion that will not create an impression before the people that we are not following the right norms. Please
may I say something, Mr. President?
Explain yourself.
Kung nakasakit mo po yung isang aktuasyon ko po, I really did it purposely. Because totoo naman po na talagang shrill ang voice na nasasaktan ng tainga ko eh. Ang kuwang ko lamang po ay dapat po lamang na kahit ang mga senador, mga judges at kami mga hamak lamang prosecutor dito, ang pinaka-importante po sa isang tao ay respeto. Ang nagdedemand, kung nagdedemand ka ng respeto, dapat respetuhin mo doon itong mga abogadong ito. Habang sapagkat yung human dignity, wala pong katulad dyan.
Trial suspended for several minutes.
Diyan ka eh. Ito ko eh. Ginaganyan mo ako, pinakita sa akin ang video mo eh.